Experts are now a standard part of the legal system, testifying in more than 80% of all trials. This creates a constant tension between two different worlds. Attorneys operate in an adversarial system, where the goal is to sway a jury, while scientists are expected to focus strictly on objective data. If an examiner prioritizes the attorney's goals over the evidence, they risk being labeled a hired gun. Once a witness is seen as someone who provides opinions for a price, the scientific foundation of their entire case disappears. To manage this pressure, examiners rely on two layers of conduct. First are personal ethics, the rules you internalize to measure your own work, and second are professional codes of responsibility, which are the external standards applied by licensing and certifying bodies. Technical proficiency in recovering data is only valuable if the examiner can defend their objectivity. If your analysis is compromised by bias, the court can find your findings inadmissible, rendering the technical work useless to the case. Ethical risks often appear before you even see the evidence. In opinion shopping, an attorney might consult you just to see if you'll provide a favorable conclusion before they decide to formally hire you. There is also the disqualification ploy. Here, an attorney contacts multiple experts to share confidential case details, intentionally creating a conflict of interest that prevents the opposing counsel from hiring those same experts. The primary defense against these tactics is the formal intake form. This document identifies the parties involved and exposes potential conflicts of interest before any data is exchanged or analyzed. Establishing these boundaries in the administrative phase is a requirement for legal survival. It ensures you are not accidentally compromised before the investigation even begins. Responsibility also extends to the tools you use. The software you choose to recover and track evidence is just as subject to ethical scrutiny as your testimony. Using pirated software or borrowing code from other products without acknowledgement is more than a copyright violation. It introduces questions about the reliability and integrity of your results. During a trial, opposing counsel can demand verification that your tools are properly licensed. If the software is found to be inappropriately acquired, a judge can disqualify the evidence you discovered with it. Technical integrity requires total transparency. An examiner's reputation is tied to the fact that their tools are both scientifically validated and legally licensed. Professional organizations like the ISFCE, HTCIA, and IACIS provide external codes to reinforce this transparency. Their shared mandate is absolute objectivity, placing the preservation of truth above loyalty to a specific client. Despite these codes, every human examiner has personal biases. The challenge is proactively controlling those biases so they don't influence the final report. To catch these human errors, the industry uses a formal peer review process. This allows a second set of eyes to verify that the findings are supported by the data. Blind reviews are designed to minimize interpersonal bias. In a single blind review, the reviewer doesn't know the creator. In double and triple blind reviews, identifying labels are redacted, so the work is judged solely on its technical merit. In contrast, collaborative and open reviews allow for direct feedback and communication. These are used to gather a broad consensus, often drawing on input from both experts and non-experts to refine the report. This rigorous validation process takes an individual's technical opinion and tests it until it becomes a stable, court-ready scientific finding. When the case goes to trial, your role is clearly defined. As a fact witness, you testify only to the raw data you recovered during the evidence recovery process. As an expert witness, you go further, offering an opinion based on your training and experience. You can testify to these opinions even if you weren't present when the original event happened. Expect pressure during this phase. Opposing counsel may use depositions to make you uncomfortable, sometimes inquiring into your personal finances to try and rattle your confidence before the trial. The American Bar Association provides a critical legal distinction here. Unlike attorneys, expert witnesses do not owe a duty of loyalty to their clients. Your professional obligation is to the facts of the case, not the person paying for your time. This is reinforced by the Daubert standard, which tasks the expert with presenting a complete and unbiased picture of the relevant research. In a system designed for adversarial advocacy, the examiner's role is to provide a stable point of objective truth. Following these ethical codes ensures that the technical evidence remains reliable and stands up to the pressures of the court.